Good morning, my friends. Today's topic is vicarious liability. It is coming under law of torts. My name is K. Umesh Rao. I am requesting you to subscribe to this channel as it gives motivation for me to give more and more classes. Now, what is vicarious liability? Master and servant relationship, principle on which theory of vicarious liability developed. Master's liability to the wrongful acts of the servant. Exception to the rule, master is held liable. What is vicarious liability? Man is liable for his own wrongful acts. He is not liable for the wrongful acts of other persons. A man is held liable for the wrongful acts of others under certain circumstances. This is known as vicarious liability. Master is liable for the wrongful acts committed by the servants. His liability is joint as well as several. Representatives of dead man is liable for the contractual liability and in the case of defamation also. Partners are liable. Their liability is joint and several. Their relationship is that of principal and agent. Principal is liable for his agents. Their liability is joint and several. State is liable for the acts of the servant in the course of employment. Master and servant relationship. The tort committed by the servants and it is committed in the course of employment. Who is servant? Servant is one who is under the control of master. Servant is an agent of employer. Who is master? Master has a power of selection of servant. Master pays wages. Master control the method of work. Master can suspend or dismiss servant. Master has ownership of tools. Master gets profit or loss. Why master is liable for the torts committed by the servants? What is the principle under which this theory developed? First, he who does an act through another is deemed in law as acting himself. Here master, he does an act through servant. Hence, law presumes that it is done by master only. Another, master is in better position. He is respondent superior. He is better position to meet the claim of the injured person. Master has a larger pocket and he can pass on the liability to the insurance company. Hence, he is liable. Master's liability to the wrongful acts of the servant. Servant is an agent. Servant is a slave. He is acting in the course of employment. Employer is not liable for an act in authorized mode of doing unauthorized work. Employer is not liable for an act done in unauthorized mode of doing authorized work. If the act is within the scope of the employment, master is vicariously liable. For example, government jeep was driven by a clerk. With the permission of the driver, he had consumed liquor while driving, he met with an accident. It is held that government is vicariously liable because act is within the scope of employment, he is liable. Another example, driver of the truck on master's business. He left the truck with the engine running. Truck was in charge of the cleaner. Driver went to the nearby shop and truck was in charge of the cleaner. While engine was in running condition, truck met with an accident and master is liable. If the servant is not acting within the course of employment and doing for himself at the accident, then the master is not liable. What is the meaning of in the course of employment? Because servant should be in the course of employment, then only master is liable. Case, Driver entrusted his car to cleaner. Driver gave the car to the cleaner for taking to driving test at RTO office. Accident happened. Driver was not in the vehicle at that time. Car was not using for master's business. The act of the cleaner was beyond the scope of employee. So, master is liable for the wrongful act but unauthorized mode of doing authorized by the master. Another case, cases done beyond the scope of the act, implied authority given. Owner of the car ordered the servant to take car directly to garage, but he has took a different route. He had cut a different route, shortcut route, which was not suggested by the master. Because he has to attend some private work, accident took place. In such a case also, master is held liable. Servant while going to the place of work and returning there from his acts, it is in the course of employment, and servant is travelling in the employer's time and journey back was in the course of employment. Hence, employer is held liable. Acts within the implied authority is always in the course of employment. For example, manager of the car was driving a car of the company on its journey from Nagpur to Purandana for company's business. Manager took one Purushottam as a passenger in the car. Car met with an accident because of the negligence of the manager. Supreme Court held that manager is a responsible officer of the company. He permitted Purushottam in the car. Driver being a manager, it is presumed that the manager had authority to carry Purushottam. He was acting in the course of employment. Dishonest and criminal act of the servant. Dishonest and criminal act of the servant. Master is not liable for dishonest and criminal act of the servant where the servant commits a wrongful act. Window cleaner steals an article from the room in which he was cleaning. It is held that employer is not liable. Another case, Lloyd versus Graysmith Company. Lloyd was a owner. She had 2 cottages. She approached a solicitor to dispose them and she is not satisfied with her income. Clerk of the defendant company approached her at her residence and obtained her signature saying that they were sale deeds. In good faith she signed on these papers. These papers were not sale deed but gift papers. Clerk sold the cottages, misappropriate money. Lloyd sued the company for damages. House of Lords held that Clerk acted solely for his personal benefit without the knowledge of the principal. But he did the fraud during the employment and in the course of employment, hence master is liable. Master is not liable for the torts committed by the servant whose appointment is compulsory under law. Master is compulsory means master has no power to select servant, then master is not liable. Another is common employment. Master is not responsible for the negligent harm done by one of his servant to a fellow servant engaged in the common employment. Here, negligent harm done by his servant to a fellow servant, common employment, master is not liable. Master is not liable for the torts of his independent contractor. Who is independent contractor? Independent contractor is one who undertakes some work but not controlled as to the method of work. So, employer is not liable. So, master is not liable for the torts of independent contractor. Liability to master is not liable towards trespassers. Master is not liable to the lawful visitors. Negligence of servant means master is liability. Acts done outside the course of employment, master is not liable. First one is master and servant liability. Second one is dead man's representative. Dead man cannot be punished in his grave, but in civil law, this principle doesn't apply. In the case of defamatory statement, legal representative is liable to pay compensation. If dead man has no property, he is not liable. Death does not discharge person from the contractual liabilities. Partner and partnership firm, their relationship is principal and agent, and liability is joint and several, and they are liable vicariously. Principal agent, liability is joint and several, and vicariously they are liable. State, in olden days, there is a principle which says king can do no wrong. Now crown can also be sued for Servants Act, but only in the course of employment, and he is vicariously liable. Thank you.